Hi, folks. Next up is This Week in Law. I'm Denise Howell. Mike Keyes, Andrew Torres, and Matt Curtis are joining me this week. We'll discuss whether the rational basis test is rational. Can you trademark the devil's horns? Does the right of publicity preempt copyright law? Can we agree not to compete forever? And how close is too close to a sea lion? All this and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keyes, and Matt Curtis. Recorded June 16th, 2017. Dr. Seuss in the Grotto with an Orion slave girl. This episode of This Week in Law is brought to you by Betterment, the largest independent online financial advisor. For one low, transparent fee, Betterment gives you personalized advice and invests your money. For a limited time, you can get up to 6 months managed for free. Learn more at betterment.com/TWiL. Hi, folks. It's Denise Howell, and you're joining us for This Week in Law. Welcome back to the show, or welcome to the show if you're a new listener or viewer. This is the place where we get together each week to discuss all the interesting developments at the intersection of law and technology and how those two things interrelate, how technology is always pushing the boundaries of existing law, and how law is struggling to keep up with what we're all doing with our devices in the world. So we've got a great panel of folks to discuss those issues with you here today, help you hopefully make sense of some of the things that you've been hearing about or wondering about. Joining us as our guest today is Andrew Torres. He's a lawyer and author, and he practices business litigation in Baltimore, Maryland, and in Washington, D.C. He also co-hosts the Opening Arguments podcast. He's also a recovering blogger, used to contribute to the blog Suits by Suits. Welcome to the show, Andrew.
Oh, Denise, thank you very much for having me.
Great to see you. I get to be on your show next week, so we're doing a little show exchange here. I'm very excited about that. Also with us here this week are my two co-hosts, Mike Keyes, who is a partner at the Dorsey firm in Seattle. Hey, Mike.
Hello, Denise. Great to be with you as always. Super excited about today's show.
I know, me too. Great stuff to talk about today. Also with us is Matt Curtis, our intern and co-host. Hello, Matt.
Hi. Excited to be on.
Excited to see you. Excited to see your bow tie. That thing is awesome.
Thank you.
Matt's a law student at Notre Dame. We're glad that you're here. Isn't it kind of finals season?
Finals have passed. I'm in DC for this part of my summer, and thankfully I don't have to think about finals.
Oh, that's great. You and Andrew are in the same neck of the woods for the show then.
Yeah.
Awesome. All right. Well, we have developments breaking in the news this morning that we want to get to and talk over a little bit. So we're going to start out talking about crimes and justice. If you've been paying attention to the news at all in the last couple of weeks, you have probably heard of this trial that has been going on in Massachusetts involving a woman named Michelle Carter. She has been on trial for encouraging her then boyfriend through text messages to commit suicide and to go through with a suicide that he seems to have struggled with quite a bit. The two of them, from my understanding, both of them had various depression and other emotional, psychological issues, and just a tragic situation that involved Ms. Carter sending messages to a young man, her then boyfriend, who was in a bad place. His name was Roy. I'm forgetting his last name here. But he was going back and forth over whether or not he should continue living. And Ms. Carter seemed to have gotten, well, at first she was urging him to get some help and go back to a mental health facility. And then she seems to have come to this conclusion that he'd be happier in heaven, and encouraged him to go forward with plans that he had made to commit suicide by getting a generator and filling his truck, I believe it was, with carbon monoxide. There was even a text exchange between the two of them, apparently, while he was in the process, or maybe actually they were talking by phone for some 40 minutes or so, which wasn't recorded. So nobody quite knows what was said there, but there was an exchange between Miss Carter and one of her friends after he was already found dead in his car, or had already died in his car, that she had told him to get back in. So apparently he had even struggled with it to the point where he'd climbed out and, she told him to get back in there. So I just, sort of a completely outlandish story that was told in this court. And the commentary that I was getting on it before this morning seemed pretty uniform in thinking that under Massachusetts law, Ms. Carter was not going to be found guilty of involuntary manslaughter. But in fact, she was. A judge this morning issued a ruling that she, in fact, was virtually there through her text messages, and that her virtual presence at the scene contributed to this young man's demise. So the legal process will, I'm sure, continue grinding its wheels about that determination. But I bring it up on the show here today because it's the second time in the last year that we've had the opportunity to think about and consider and discuss on the show how real world actions that can do real world harm to people might be carried out via a remote technology. And the prior instance that we discussed had to do with the journalist Kurt Eichenwald, who suffered a seizure when a man named John Rain Rivello sent him a tweet that strobed and caused him to have an epileptic fit, and was then arrested and charged with assault for that. So we have another instance here, not using a social platform, but using text messaging, where someone not at the scene caused harm to someone and is being called to the mat for it, is being held accountable for it. So let's start with you, Andrew. What do you think of all this?
Well, with the caveat that I'm a civil lawyer and not a criminal lawyer, but that doesn't stop me from having opinions. I think this is pretty distinguishable from the Eichenwald case, right? Like, whenever you're looking at technology, right, what the court is going to do is try and analogize it to something from 100 years ago with which it's familiar. And to me, like, the Eichenwald case is kind of like, mailing, poisonous dust to somebody, right? Mailing anthrax spores to somebody, right? Like, you absolutely know when somebody has that kind of condition that's sending a message that's going to trigger that seizure, right? You can infer intent from that. And to me, when I read the story here in Massachusetts, what struck me was sort of the difference, and courts kind of trying to struggle with things that could sound differently if they were a face-to-face conversation, if there were a phone conversation, as opposed to being a text message, right? So, like, some of the really, really bad-looking texts here are, her saying no, when the victim who ultimately committed suicide said, "I'm gonna do it eventually. I don't really know what I'm waiting for, but I have everything lined up." And then she responds, Michelle Carter responds, no, you're not, Conrad. Last night was it. You keep pushing it off and you say you'll do it, but you never do. It's always going to be that way if you don't take action. You're just making it harder on yourself by pushing it off. You just have to do it. If you don't do it now, you're never going to do it. And like, I agree that sounds bad, but I sort of think about it as, written down, it looks a lot worse than, you could sort of imagine that coming up in a conversation where we wouldn't necessarily infer the same level of intent. So that was my take.
Yeah, and I think the ACLU would agree with you. They are a bit up in arms about this decision and are worried about Ms. Carter's conviction chilling end-of-life discussions between loved ones in Massachusetts. So they seem to be wanting to get involved and push back on this decision. Mike, what do you think?
Well, it's just an incredibly gut-wrenching story, and our hearts go out to the victims or the victim rather, and the family member of the victim. It's just a really tragic situation. The charge, and again, like Andrew, I'm not a criminal lawyer, but the charge here is somewhat interesting. As I understand it, it was involuntary manslaughter, which under Massachusetts law is the causing unintentionally the death of somebody by reckless conduct. So you've got this series of text messages that Andrew and Denise that you had mentioned a moment ago, and then you've got the interaction during the time when the poor fellow was in his car in the Kmart parking lot, where she somehow, and I'm not sure if it was during a phone conversation or during a series of text messages, she orders him back into the car, saying, "Get back in there," knowing that he had already kind of come out and was, really worried about going all the way here. And so that is really what put, I think, based on what the judge was saying during the findings, that that's what kind of really sounds like that's what put the judge over the edge, finding her guilty of this crime. But that almost sounds to me like not the unintentional causing of somebody's death, but knowing that you're telling somebody to get back into a dangerous situation, knowing what his intent was, and knowing that this could very well end up in death. That doesn't sound unintentional to me. That seems to me like that's more intentional than not. So I don't know. It's very, very tragic case, raises all sorts of interesting issues. We'll have to see what plays out. Presumably there will be an appeal.
Right. I was actually kind of surprised. And again, none of us are criminal lawyers. So we are offering our opinions from our civil law backgrounds and expertise. But I was surprised actually that the prosecutor on these facts went with an involuntary manslaughter charge. I'm sure they decided to bring whatever they thought they had the best chance of success on, and that demonstrating that is certainly not as difficult as something like second-degree murder. But there does seem to have been, from the exchanges here, an intent that the young man, Roy, would wind up deceased, at least on Ms. Carter's part. So it wasn't like when I think of involuntary manslaughter, I think of car accidents, recklessly driving your car and you unfortunately have an incident where someone winds up dead. There was no accident about this young man's death, it seems. So like you, Mike, I'm not surprised, just based on the knee-jerk emotional pull of this case that the woman wound up being held responsible. What do you think, Matt?
I think that there's good reason why the prosecutor did not bring this under a typical manslaughter case. There is a doctrine called the Voluntary Intervening Act doctrine. I don't know if it specifically applies to Massachusetts, but where a victim acts outside of the control and they break the chain of causation, suicide is that act. There's a case called People v. Campbell, where an individual guilt-tripped another man who had slept with his wife into committing suicide and actually gave him the gun. And then the other individual ended up killing himself, and they found that was not manslaughter or murder. There's also the Kevorkian case, where Dr. Kevorkian gave patients the not only provided them how to kill themselves, but also gave them the devices to kill themselves. But the individual act of like turning on the switch was what made it so that he wasn't found guilty. The only way that they could have got that is through like the eggshell doctrine, but they would have had to have like the cases where that is. There's a case called Stefferson v. State where a suicide was ruled murder, but only in a kidnapping setting. So it would have been really difficult to bring it under anything else than this. Logically, it's inconsistent, as Mike pointed out, to bring it under involuntary. But I just don't think I don't think the precedent was there for anything else.
Yeah, I think those are really. Oh, sorry.
I was just going to say, you bring up a good point that came up a lot as people were watching this case and opining that she would likely not be found guilty under Massachusetts law, and that is that she wasn't involved in any of the provisions of the actual mechanisms of his death, that Roy went out and arranged all that and purchased everything he needed on his own. What were you going to say, Andrew?
Yeah, I was just going to say that the defendant here, Michelle Carter, was 17. So, I think there was also that probably factored into the decision in terms of, trying to evaluate her mental state and whether you wanted to make that an issue in the trial at all. And I have not heard the eggshell doctrine in like 20 years. So good on Matt for that one.
Great. Isn't it fun to have a law student on with us? They remember all this stuff. They know it. They're learning it now.
I have my criminal law notes up on
nice.
my other computer. So
I went to dig mine up, but they're in quill and ink. So
yes.
Exactly.
I have the benefit of Control F.
That's right. What does your coffee mug say, Mike?
Yeah, 40 isn't old if you're a tree. So
yes, there we go. All right, let us move on to some other topics, somewhat at least tangentially related to the hallowed halls of Washington and other lawmaking venues because they involve legislation and policy. We didn't wind up discussing this last week when we had DTA's counsel on, but it's something that I dug up as I was researching that show when Natalie Nickel joined us. And what it is pretty interesting. We hear a lot about Uber and Airbnb disrupting various businesses and throwing regulatory structures for a loop. But you don't really necessarily think about that in the arena of eyeglasses, but maybe you should, because Warby Parker, and I think there are others out there that are also doing this, is attempting to disrupt the way that you get a prescription for glasses and then obtain your glasses. Traditionally, for those of us who took our law school notes in quill, and for various others of you out there as well, you go to an optometrist or an ophthalmologist. You take the famous eye exam with the sideways and upside down E's, and you have the, God, I don't know what that device is, but the thing where they slide the lenses in front of your eyes and you decide what looks clear, and they determine your prescription. Well, Warby Parker now has an app for that. They have an app that basically walks you through performing an eye exam via the app. And then I assume that the way it works is once your prescription has been determined, you can just order directly from Warby Parker, cutting the middleman out of things. And there are various states that don't like this at all. South Carolina, Georgia, and Indiana being examples. And then there are other states like the state of Virginia that have actually passed laws protecting ocular telemedicine services, thinking that this is a good thing for consumers, a way for people to save money, as long as all of the various other things that you would get with an optometrist or an ophthalmologist, including the privacy of your medical records and the quality of care, are somehow assured. And as I said, various other startups have attempted this. Opternative is one that comes up. But Warby Parker has actually lobbied state lawmakers and talked to them in advance, and seems to be going about trying to smooth the way for itself rather than just launching the app and then dealing with the fallout of it. What do you think of this, Mike?
Well, I think it's wonderful. It sounds great. I actually am in need of some new glasses. And so if it were available here in Washington, I'm not sure if it is or isn't. Doesn't sound like it is. But if it was available, I'd certainly give it a shot. I can see some of the potential criticism here, though, at least as I understand it from looking at some of the articles. This doesn't provide a comprehensive eye exam. Maybe it won't screen you for glaucoma and some of these other ailments. So, which, as I understand, is part and parcel of the exam when you would go in to see an eye doctor to get a prescription. So, I could see that. Still maybe needs to be worked out a little bit, but geez, I just think this is a wonderful idea.
It's sort of indicative of where other services could go too. There are a whole host of medical services that maybe could be done without visiting an office. Does that give you pause at all, Matt?
No.
Okay.
Mostly because the recommendation of the Eye Institute, I can't remember what it is, but they recommend that you get your vision checked every 5 to 10 years. And so I believe what Warby Parker has put in place is that they will allow you to get prescriptions based on a eye exam for up to 5 years. I know that's what Opternative has done. To me, it worries me that these state regulators are putting in barriers to entry for companies like this. I think this is a great service, and there's not, after the 5 years, I think that there's legitimate reason why, we need to go and actually see a doctor. But to the extent that it's just propping up the cost of going to get new glasses, I think it's a bad thing.
Right. And it's probably one step better than just going and grabbing readers from your local drugstore and hoping for the best. Also, thank you for pronouncing Opternative the way that I'm sure it's supposed to be pronounced, and not Opternative, which wasn't making any sense to me at all.
That's all right.
That's all right. Andrew, what do you think? Are you going to try this out if it's available in Maryland or DC?
Yeah, I would definitely try it out. I mean, I think that Matt's comments were sort of dead on. This is clearly going to be fought at the legislative level, and it is kind of the classic, sort of upstart, smaller company. Warby Parker is not that small, but you're talking about kind of disaggregating the cost of entry. Opternative has filed suit in South Carolina. I have taken a look at that lawsuit, and their allegations are that they're being deprived of due process and equal protection. And, since eye care providing companies are not a protected class, right? Like the law only has to survive strict scrutiny. And I think that, the health justification is probably going to be sufficient, for the South Carolina Supreme Court to conclude that the law passes strict scrutiny. So, the future is really persuading voters at the state level to, not allow kind of, big medicine in their state to flex their legislative and lobbying muscles and put these kind of barriers into practice.
Can I jump in?
We're going to go ahead.
Yeah. So when we're talking about not having strict scrutiny, this lawsuit was brought on the basis of an economic liberty claim. And so they analyzed that under the rational basis test. And Williams v. Lee Optical is a 54, I'm probably wrong on that, case where it says that judges, when they're looking for a rational basis of a law, not only do they allow any rational basis which was not put forward during the legislation process, but the judges are also required to make up a rational basis for the law. So it is utterly ridiculous.
I
that's the state of the law.
Rational. Yeah, I meant rational basis. I apologize for that. But the test is right. It's the same fog mirror test that so long as there's any articulable rational basis that it's the legislation is going to pass and it's not going to be held to violate the Constitution.
I feel like we should add a rule to the TWiL drinking game that in addition to whenever any Latin or reference to Monty Python is uttered on the show, that if we're staying strict scrutiny or rational basis or any other constitutional test for the validity of a law, that's got to be a qualifying event too. So
I agree. Drinks are on me for the first round for the verbal slip-up.
Let's see. Let's make eye-opening app our first MCLE passphrase for this episode of This Week in Law. We put a couple of phrases in the show in case you are listening to or watching our show for continuing legal education credit in your area. Or for professional credit in some other field, and you have an oversight board that likes to have a verification method in place to show that you didn't just write down episode 390 of This Week in Law on a list and turn it in, that you can actually verify with us if you need to, that you watched or listened to this show. If you'd like more information about that, please go to wiki.twit.tv, find our This Week in Law page there, and you'll find a nice chart to the 50 jurisdictions of the United States where lawyers may have to comply with their continuing legal education requirements. So we'll put another one in the show before too long. But before we leave this topic of tech businesses and technologically enabled tools disrupting local regulatory schemes, I just wanted to mention that here in Southern California, we had a hearing on Tuesday of this week in LA at City Hall, still grappling over how people should be able to do short-term rentals in LA County. And I think there wasn't really an outcome there. People got up and spoke and debated. And what's being considered is a draft rule that currently calls for a 180-day cap on the number of days rooms can be rented in a year, various other restrictions too. And it also requires that the people doing the listing of their properties for short-term rental actually live at the property. Now, as someone who's used Airbnb on a couple of occasions, I find that a bug, not a feature. I like to get the property all on my own if that's possible. So I would imagine that would be not helpful to the short-term renter marketplace. What do you think, Matt, about short-term rentals and the growing pains that they continue to go through everywhere?
Yeah, I think we've seen this in New York. I believe that they passed similar legislation. I think is more restrictive. I completely agree with you. I don't want to stay at I love Airbnb, but I do not want to stay if someone's living there. That's a serious bug. And this is the same type of legislation that's it's not related to a fundamental right, and therefore it's going to go into the rational basis test. So to the extent it gets in, anyone who has built a business around this or anyone who has is able to pay for their housing by using this. Say they do live in their house and they just can't afford to live there unless they have someone staying there 200 days out of the year. Well, they don't have any recourse through the courts. Essentially, I mean, they can bring a rational basis claim, but it's highly unlikely that they're going to win. So I think that they have real consequences, and I'm not for them.
I will say we stayed in an Airbnb in Utah once where we got some mighty fine pancakes for breakfast from the owners who lived on site. So I suppose it can have its perks. Andrew, do you know how things are in your area for these kinds of regulations, what the climate is there?
Yeah, we do not in Maryland have laws like this restricting Airbnbs, but it wouldn't surprise me if there were older laws to which it could potentially be analogized, right? Like the issue, as I understand it, that's come up in a number of jurisdictions are laws that apply in the sort of the standard landlord-tenant context, right? That say, you can't rent your house out for a couple of days on the weekend and then come back, or subleasing, or all sorts of other things that come into play. But these laws haven't made it here, and I would just say that I am very comfortable outsourcing all of my legal opinions to Matt on for the conceivable future, like that. Just dead on that.
Yes. We love you, Matt. Mike, any thoughts on the Seattle area and short-term rentals?
I'm not aware of what the current state of affairs is here with respect to regulations such as these, but it strikes me that this is a solution in search of a problem. There's been criticisms of Airbnb and some of these other rental services, but look, I mean, this is really providing a solution for people that are looking for both short and long-term rentals, and so long as people are safe and that they're otherwise complying with the going regulations, it seems to me that live and let live. And the fact that these regulations are requiring somebody to actually live there with the renters, I mean, that's just a little creepy, frankly.
Yes.
Why do that? Just let them. If you have the benefit of somebody's dwelling without the owner there, so much the better, as far as I'm concerned.
Yeah, I don't know. I think there might be some sort of feeling that there's more accountability, more looking after what the guests are up to, that they're not disrupting the neighborhood. I think that those kinds of policy concerns are in people's heads when they put those restrictions in, but I'm with you in general. Pancakes aside, I would rather get the place without its owner there. In a moment, go ahead.
We've got the other side of the equation. We've got Norman Bates, for example. He lives close by. I mean, there's a downside to that too.
Right. And the creepy person who has their home tricked out to take surveillance of you as you're doing your Airbnb business, which, you may not have the tech at hand to do a sweep for before you tuck in and make yourself at home. All right, all kinds of considerations there, but we're going to change gears and in a moment come back and tell you why July 12th is going to be a big day for net neutrality. But before we do that, we're going to thank our sponsor for this episode of This Week in Law. This episode is brought to you by Betterment, the largest independent online financial advisor. Betterment is designed to help improve customers' long-term returns and lower taxes for retirement planning, building wealth, and other financial goals. Betterment takes advanced investment strategies and uses technology to deliver them to more than 250,000 customers. Based on the information you share, Betterment will make tailored recommendations on decisions like how much to invest, how much risk to take on in your portfolio, and the type of investment account you should have. On average, Betterment's tax-coordinated portfolio can increase portfolio value by an estimated 15% over 30 years. Betterment gives you a clear view of your net worth when you sync your outside accounts, such as bank accounts and other investments. Another reason to choose Betterment: low, transparent advisory fees compared to traditional services. Only 0.25% on assets under management, with an option to upgrade to 0.4 or 0.5% for access to a certified financial planner or a licensed financial expert. Betterment cares about keeping your money and data secure, which is why they have advanced data encryption and login protection. If you want to talk to someone about your specific financial situation, you can access their team of licensed financial experts. Investing involves risk. For a limited time, you can get up to 6 months managed for free. For more information, visit betterment.com/TWiL. That's betterment.com/TWiL. Betterment, rethink what your money can do. And one thing we're thinking about what net companies can do in July is take a stand on net neutrality. July 12th is the day that is the designated online protest. in favor of keeping the open internet rules in place. Etsy, Amazon, Reddit, Mozilla, the ACLU, and others have all agreed that they will show their support for net neutrality on July 12th. We're not quite sure how that's going to look. Former protests have, you might remember a similar protest that involved a net slowdown that showed you a spinning, loading kind of wheel in support of net neutrality to get people's attention and to point them in the direction, give them some guidance on how they can make their opinion heard on the issue. The sort of late-breaking news on this front is that Netflix has signed on. Netflix was instrumental in the original process of enacting the open internet rules. And Reed Hastings, its CEO, has recently commented how net neutrality has become less of a priority for the company because they have grown to the size where they are able to negotiate deals that smaller companies, such as they were when they started out, could not do. But Netflix has come out and tweeted just yesterday that it will never outgrow the fight for net neutrality and that everyone deserves an open internet, and pointing people towards the battleforthenet.com page, which is the organizing point for the July 12th protest. So this is all going to take place. And one other thing I just wanted to point people toward, if you are interested in involving yourself in this discussion, we are expecting a determination from the FCC in the fall as to the fate of the current open internet rules. And the FCC has been taking comments, will continue to take comments. Gigi Sohn, who is a former counselor to former FCC chair Tom Wheeler, has a piece up at Mashable suggesting how to write, giving you some guidelines for how to write an effective comment, and really good advice for you to just get reflective and not strident, not spit back sound bites, but some of the points she encourages you to think about are how the net neutrality rules have affected you, what you understand when you're purchasing broadband internet access. What do you think that entails? What do you think that's getting you? What choices do you or don't you have for broadband internet access? And what do you think the role of the FCC should be in overseeing the market for this kind of access? She has much more detail on those points in her piece. So I encourage you to check that out if you're planning to weigh in and give the FCC a piece of your mind. Matt, do you think you will do so?
Yeah, and I certainly think that the way that Gigi set it up is it's really important how you make comments to administrative bodies. And so I highly recommend going through that. I am the least likely person to be at a protest, but I might actually do this online one. I think that the benefits of net neutrality just far outweigh the cost.
There we go. Mike, do you agree?
I agree with Matt on all fronts. I'm also unlikely to participate in any protest.
Got it. And Andrew, I'm wondering how the net neutrality debate is making itself apparent in your neck of the woods around Washington, D.C. Is this something that's even on people's radar?
Yeah, it is. I'm going to give a slightly different perspective because I definitely agree with the ideas behind net neutrality. If you'll forgive the plug, I did a two-part episode of this on my show. It was episodes 64 and 65. So we spent an hour and a half between those two shows looking at kind of the history of the fact that that internet regulation has historically there's been overlapping jurisdiction between both the Federal Trade Commission and the FCC, the Federal Communications Commission. And one of the unintended consequences of the political push for net neutrality in late into Obama's term was that the Obama era FCC in 2016 made the decision to classify broadband ISPs as Title II carriers in order to promulgate the 2016 version of net neutrality. That had the unintentional side effect of stripping the Federal Trade Commission, which for 20 plus years has been pursuing, fraudulent consumer practices and had a robust internal internet privacy guideline. It stripped them of jurisdiction. And so all of a sudden then late in 2016, the Obama FCC had to try and craft some internet privacy rules to fill that gap. And the problem with that is there's a very, very obscure piece of legislation that dates back to the Newt Gingrich era, 1998 Congress. It's called the Congressional Review Act that allows the Senate to bypass the ordinary rules on the filibuster, pass with a bare majority so long as it passes the House, a joint resolution that disapproves of any executive orders that have been passed within the past, I think it's 30 congressional business days, right? And a congressional, 30 congressional business days is like a year and a half by Congress's time. So all of a sudden, there was this bill at the beginning of the year, SJR 34, that undid the 2016 FCC internet privacy rules and sort of, left us open kind of without any protection. That was you probably saw the coverage of that. It was called the Selling the Internet Bill, and it was the discussion was that it might lead to ISPs being able to sell off your browser history, which I think that's a little bit hyperbolic, but that kind of train wreck came about because of the switch, the internal switch to classify ISPs as Title II carriers that really no one anticipated would have this unintended consequence. So, I would just say, take care, really make sure you've educated yourself on those issues before, kind of wading into offering administrative comments. So.
Absolutely. Always a good idea. And if you would like some more information about Gigi Sohn's piece or anything else that we've referred to in the show today, please head on over to a couple of places where we aggregate all of our source materials in putting together the shows. First of all, we have a Flipboard magazine that you can subscribe to and that I'm thrilled if you would like to volunteer to contribute to. That is at flipboard.com /@dhowell, and you'll find bunch of my magazines there, including This Week in Law. Also, we have, if you're just interested in a bare list of links, tagpacker.com/user/This Week in Law. If you find episode 390 there, you'll find all the links that we've talked about in the show today. Lightening things up just a bit, let's talk about some interesting trademark developments. Mike, I know this one is near and dear to your heart. We've discussed the crowdfunded Dr. Seuss / Star Trek mashup called Oh, the Places You'll Boldly Go before on the show. We have a determination in that case now that the use of the Seuss trademarks by the mashup were fair use. Can you tell us more about that?
I sure can. So this is a case we've covered before. I blogged about it. As a matter of fact, you'll recall, Denise, that my blog post on this case was in the Dr. Seuss genre, if you will. So this is a case brought by Dr. Seuss Enterprises against a company called Comic Mix that came up with a book called Oh, the Places You'll Boldly Go. And it was a mashup of both Star Trek and Dr. Seuss. And Dr. Seuss Enterprises was not too keen on this, sued for trademark infringement and copyright infringement. And last week, the trial court ruled that the use of the trademarks, the Dr. Seuss trademarks associated with this work, was nominative fair use, meaning it was fair game for them to use it. They needed to use it in order to explain or show that they were actually having a mashup here between Dr. Seuss and the Star Trek franchise. What the court got into the copyright-related issues here, and also held that there's a question of fact as to whether this is fair use, but the opinion itself came out pretty strongly in favor of this mashup as being potentially protected. Really, the only issue that's remaining with respect to the fair use determination is whether there's harm to the original, harm to the market value for the original work. So that's something that's going to be sussed out during trial, assuming there is one if the case doesn't settle. So really fascinating case, kind of the first of its kind to really get into the boundaries of copyright when it comes to mashups, using different properties and creating a new work. So very interesting case to follow.
So I guess the original work is Oh, the Places You'll Go, not the entire body of Dr. Seuss works, I assume.
That's correct. So, of course, the market for Oh, the Places You'll Go is primarily for children. And query whether Oh, the Places You'll Boldly Go is also for children. It's probably more of a older children, young adult, old adult market that they're going after here. So, the facts still need to be determined on that. The court, said, look, we don't really have a determination here. There are no facts to suggest one way or the other whether there's market harm to the original. So we shall see.
So I'm expecting another TMCA blog post on this, Mike, in Seussian rhyme and meter. Please let us know when that is up.
I will do my best. I'm going to be in depositions all next week, but I'm going to try to find some time.
All right. Andrew, what do you think? Do you think this is for children or adults? And also, do you think it's a good thing that these fair use parameters are being clarified on both the trademark and copyright front?
Yeah, I think Mike really hit the nail on the head in describing the case. I mean, a number of things really jumped out at me. The first is the court's really lengthy discussion and evaluation on the fair use factors, which, as most of us know, I mean, fair use almost always is a really fact intensive inquiry, and so therefore when you are a defendant in a copyright lawsuit, it's on the one hand, it's nice that it's available to you, but on the other hand, if you are a small producer, if you are an independent content creator, fair use isn't likely to help you win a motion to dismiss, right? Because it's the court is going to say, well, that this is a doctrine that we typically apply at the summary judgment stage, and so the real costly aspect of litigation in terms of going through discovery is still likely to take place. So I think the fact that the court kind of clarified down those issues, resolved most of them, said, look, we think that these are in, I think the phrase was perfect equipoise, but basically, it was only a question on the market impact, sends a pretty clear signal. And I think Mike is right that this case is going to settle. I can't imagine that the estate of Dr. Seuss is going to go forward, with this ruling. The second thing is its extensive reliance on the striking down granting the motion to dismiss with respect to the trademark claim on nominative fair use of trademarks, which I haven't seen that applied in this context, right? Like, typically, you think of nominative fair use on trademarks as, right, the paradigmatic cases are the Playboy playmate who described herself in her CV and using meta tags on her website as a playmate. And, Playboy sued her for violation of their trademark, and the court held that the only way to describe yourself as a playmate is to use the trademark, right? And so, that there's a 3-part test, but you don't typically see it applied in a context in this, sort of mashup original content creation context. So I thought that was pretty interesting.
And I just can't stop thinking about how the next mashup might have to involve Playboy trademarks as well. Oh, the places you'll boldly go, including the Playboy Mansion. Why not? Next creative work on deck. Wanted to ask both of you about the procedural issue. You both seem to be of the opinion that this is going to settle, but are there reasons why interests, amici involved in this case might want to get a decision out of the Ninth Circuit as opposed to just the trial court here to have more citable, persuasive law on these fair use issues? What do you think, Andrew?
That's an interesting question that I hadn't thought about. I mean, the issue that I think you would want sort of more guidance at the appellate level on, it's addressed in this case, but I think it is really kind of ambiguous at the Circuit Court of Appeal level, is the continuing trend in the application of fair use doctrine to obviously commercial works, right? Like for a very, very long time, it was almost dispositive in the 4-part test of fair use. If a particular work was designed from the beginning to be a commercial work, that held really high weight. I mean, I don't want to say that there were no cases saying fair use, but typically those were even in those kinds of cases, they were sort of mixed use, right? Like educational textbooks and newspapers and the like. That obviously there's some profit component there, but there's also additional social purposes behind that. And the reason that I think that's important is because all of these projects are going through some sort of crowdfunding, right? Are going through, raising money on Kickstarter or ongoing support on Patreon, on sites like that. And so moving into a regime where it's no longer a part of the argument that, hey, you're raising money for this, hey, you're making money off of this, I think has the potential to be really transformative in terms of, how we view fair use on the internet going forward.
And Virgil in IRC is also making me now want someone to draw up the Seussian version of the Orion slave girl. What would that look like? I'm not sure. Matt, anything to add?
You're going to make me follow that comment? I think that, yes, getting more substantive understanding of what fair use is and when it applies. I think it'd be really nice to have something like the inter partes reviews and patents to be able to determine this in a more cost-effective way. I think that ultimately, as we've seen as we've seen copyrights just get extended and extended and extended, and we're going to have this fight in a year from now, or sometime soon, about extending copyrights. As they get extended longer, fair use logically has to get bigger, because 70 years or 95 years after someone's died, or I can't remember the exact numbers, but it's extraordinary how long these last, and we don't see the actual inventors or the actual creators litigating these rights, and we don't really know that they would. It's the interest holders of the creators that are holding this, and so I'd first of all like not to see a copyright extension, but then second of all, it would be great to get a more cost-effective way to find out if the content that I'm creating is fair use.
All right. Any final thoughts, Mike?
Nothing further. Stay tuned for my blog post, though. I'm hopefully going to get inspired this weekend.
We hope so, too. I hope so quite a bit. But you have already posted, not on Dr. Seuss, but on iconic 70s rock band Kiss and its frontman Gene Simmons, who also had an interesting trademark registration application. Can you tell us about that?
Yes. So this falls into the what in the Covfefe is going on here.
No.
I know Matt loves to talk about Covfefe, but it's
just like you love to talk about PETA.
As we talked about last week, there's a huge surge of Covfefe trademark applications before the PTO, most, if not all of which are likely to be denied. And this most recent one by Gene Simmons that was filed, I think it was either earlier this week or maybe late last week, I think falls into that Covfefe dustbin. What he has done is Kiss and frankly, a variety of rock bands over the last several decades have used the devil horn sign to express themselves during the course of their shows. Of course, the devil horn sign is this. I guess some debate whether the thumb should be out or not, but in any event, Gene Simmons has filed a trademark application with the United States Patent and Trademark Office to trademark that for entertainment services, claiming that he came up with it on his own back in the 1970s or thereabouts, and that it is a source identifier identified exclusively with him and his entertainment services that he has provided. So I think there are lots and lots and lots and lots and lots of other people that would dispute that claim. I think this is likely to be rejected by the examiner. The examiner will be looking at all sorts of outside evidence to see if this could possibly act as a source identifier, and he or she will quickly realize, if they haven't already, that this sign is used in a variety of contexts. It's actually used for signing "I love you." It's also used by a variety of rock bands and other people to express themselves during rock shows. So I don't think this is identified exclusively with Mr. Simmons or anybody else for that matter. But, hey, he wanted to file the application. He had to pay a few $100 to the federal government. So why not?
Yeah, I think that he actually would have a better shot if he'd put the thumb over the two fingers, right? Because then it wouldn't look like shaka bra from Hawaii and or California surf culture. Right. But the drawing they submitted has the thumb extended, as does the picture, I guess, they submitted with Gene Simmons and Dave Grohl illustrating the would-be trademark in action. Andrew, do you agree this one's going to go down in flames?
So, two things. Number one, it's definitely thumb over the fingers for the devil horn. Okay. I say this as somebody who came of age in the 1980s. And number two, I think the court can take judicial notice of the fact that Ronnie James Dio invented the devil horns. We all know that. So I think there's prior art here.
Okay. Matt, do you even know who we're talking about?
No, Google is getting a workout right now.
I suspected as much. Who for the rest of us who might be in the dark is Ronnie James Dio.
Ronnie James Dio, one of the founding guitarists in Ozzy Osbourne's band. And why am I blanking on Ozzy's first band? But no, he's got this whole story about how the devil horns were his grandmother's ward to ward off the evil eye, and there's a picture of him doing the devil horns, I think in 1969. So, and Kiss has never been a heavy metal band anyway, so I feel strongly about this, much more strongly than I do about any other legal aspects. So.
Andrew,
No Medius and Virgil in IRC are both telling us you're thinking of Black Sabbath.
Yeah, of course I'm thinking of Black Sabbath. I just blanked a little bit. Look, I'm on a much beloved podcast. I'm finally here, and I blanked on Black Sabbath. So, but Dio has been doing the devil horns since long before Gene Simmons put on the makeup. So.
And we're right back to our motto for the show: 40 isn't old for a tree. Matt, anything to add of a substantive nature?
Nothing substantive.
Nothing substantive. All right. Then
your homework, Matt, is to go listen to a Black Sabbath album. So
That's fair.
We'll make Black Sabbath our second MCLE passphrase for the show because why not? So write those down if you need to demonstrate that you actually watched or listened to the show today. And we will then sojourn onto the arena of Hollywood music and entertainment and have a little entertainment for you. So I actually stumbled on this link because I follow Axanar on Facebook, and they tweeted this, that there is a fan film short out there. It's available on Vimeo that was made with the various CBS, Paramount guidelines in mind. We have discussed those at length on the show that came out during the course of the Axanar litigation. I'm pulling them up right now so I can remind people what they consist of. There are a whole host of them, but you can have one film that's either 15 minutes for a single self-contained story, or you can have no more than 2 segments, not to exceed 30 minutes total. And you can't have additional seasons, episodes, parts, sequels, or remakes. Your title can't include Star Trek, the words Star Trek, various other restrictions on use of uniforms, etc., various other restrictions about it being a real fan, quote unquote, production, etc. So what we have here is one that the Axanar folks pointed to as a great example of what can be done within the new fan film restrictions. So we'd like to just play a bit of it for you in case you haven't seen it. It's called Chasing the Infinite Sky, and it is by Albert Martinez, who describes himself as a big Star Trek fan who was inspired to create. This is a non-canon, fan-made conceptual short to express his love for the franchise. So let's watch a bit of it.
We've dropped out of warp. Engines powering down.
Starfleet, this is Captain Robert Armstrong. We are heading back from the planet Mars.
Standard orbit initialize.
This is Starfleet Command. You are clear for turnaround.
Helmsman.
It's really not too bad.
Speak. Aye, Captain. Maximum warp.
I think you need to do a TWiL.
It would be good to get him on TWiL. It goes on for about 5 minutes. I think 5:20 is what it's saying on Vimeo. Great special effects. He needs some writing talent, I think. I think he's basically showing off what he can do, effect-wise here.
Copy that. We'll see you in a bit.
This is Captain Storm's team on final approach.
It may not be big studio, big budget, but it's very watchable.
Air equalization on. Albatross welcomes you. Prepare for docking. Welcome back, Captain. We've been expecting you. Proceed to docking Bay 1.
We are ready to depart.
Yeah, this is already better than half the episodes of Voyager I watched. So.
Starfleet operations, you are clear for departure.
Moorings cleared, sir.
Ahead 1/4 impulse mode.
Aye, 1/4 impulse.
I can't imagine a film like this, a fan film being made like this, say, and being available for people to watch online, say, 10 years ago.
All systems ready, sir.
It seems like we've come a huge way.
Okay, steady as she
And kudos to Albert Martinez for putting this together.
Engines are engaged and standing by.
All right, well, you can watch the whole thing at your leisure, but we just wanted to give you an idea that people are out there making fan films within the fan film guidelines. And I don't yet have the link to the guidelines in the discussion points for the show, but I'll throw them in as soon as we're done here today, in case you have become inspired to make your own. And our other entertainment-related story today relates to a company that we've talked about before that has been in the throes of its own legal battles and continues to be in the throes of its own legal battles. The Ninth Circuit recently heard oral arguments concerning VidAngel, is the name of the Utah-based company that has an interesting business model. Nominatively, it is making family-friendly filtering services available. So if you want to watch Game of Thrones without all the nudity and incest, I don't know if it can take out the incest or not. That would be hard. That's a big plot point. But, you know, a cleaner version of some of these things. That's what VidAngel aims to supply. Now, I tried out VidAngel and learned firsthand that you can also just watch the unfiltered movies as well. You don't have to turn on their filtering, at least when I tested it out, you did not. And they had this interesting business model where you pay $1 per view of the movie, but you have to deposit $20 at a time. So they have just launched a new platform, is why they're in the news. They are awaiting, along with the studios that have sued them, what the Ninth Circuit will do about their platform. Is this something you've paid attention to, Andrew?
Not before now. Well, not the VidAngel stuff, not before now. And I don't. I mean, to me, they have a real clear problem with interfering with the derivative use rights of the copyright holders, right? Because my understanding is that what VidAngel does is, you know, it's essentially it has a hard drive. It takes the content, the Game of Thrones or whatever, and then runs its algorithm and then spits out an edited version of that content. And I just don't see. I mean, I don't know what the commercial market is for Game of Thrones without, you know, the nudity. I think the article said, you know, if you filtered out everything that was objectionable in Game of Thrones, you'd have the title sequence, and that's about it. But
which is a great title sequence.
Yeah, no, it's a totally cool title sequence, but still, like, it's hard to see how that doesn't infringe on the original copyright holder's right to create derivative works from it. I'd be curious if anybody disagrees. The Star Trek stuff, super cool. Have you seen Star Trek Continues, which is on YouTube?
I don't think I have yet. I may have watched some of it. People point me to this stuff from time to time, and I'll pull it up and watch. And I don't know if I registered the title.
So basically, they've recreated their goal was to recreate visually the set of the original series, right? And so it's the cast, it's the set, it's the entire, and it looks like a high def version of the 1960s, the original series, right? Like it's
the place.
It's really
it actually exists in the real world, and you can go visit it in New York somewhere.
They have built sets and the like, and so it's clear. It's interesting to me because I looked up the guidelines when we were talking the story. I posted them in the chat room, and this clearly violates all of those guidelines, right? Like it has Star Trek in the title. It's longer than 30 minutes. It's episodic. They've raised more than $50,000 on Kickstarter. So it's interesting to me that there was some sort of détente there where, they were able to continue to produce that short. I think they've produced like 8 or 9 episodes. So me that always raises the question when you're talking about selective enforcement of copyright, like what, how whether that's going to, prejudice CBS's rights to enforce their copyright down the road.
Right. And I think we did discuss them in some detail back when the Axanar case was still pending, because we thought that they might be impacted by that case. And they were in existence and making shows before the guidelines went into effect. So I don't know this for a fact, but maybe they're just, the studios are considering them grandfathered in or, not a threat enough to sue over. Mike, any thoughts about Star Trek or VidAngel?
Yeah, so the VidAngel case is really interesting. There was an injunction that was issued by the trial court back in December, and that is on appeal right now. So the original business model, as I understand it, was dedicated to VidAngel taking a DVD for its customer, ripping it, and then streaming it to that customer with the sanitized version of the content. Now, how I think they tried to comply with copyright law is they kept the DVD that was ripped essentially in a quote-unquote lockbox and kept it kind of segregated, and it would be allocated to that particular customer. It's not like they were doing multiple streams of that for various customers. You had one DVD that was ripped, given to that customer. That customer was charged $20 for it, and then when you turn it back in, you would get a $19 credit. So that was essentially the business model that was enjoined by the trial court. And what the trial court said is, one, ripping the DVD itself is a violation of the DMCA, the Digital Millennium Copyright Act. And then the act of providing the sanitized stream is also an independent violation of the Copyright Act. So this new business model that was just launched, or I'm not sure if it's just launched or if they just announced it, and if they're going to seek permission from the court to ensure that it doesn't run afoul of the injunction. But it sounds like this new business model that they've come up with, somewhat on the fly, is somehow hooked up to whatever streaming service you're used and will provide these editing features as it's streamed to you. So it doesn't sound like the old business model of ripping DVDs is still involved, but it's kind of done right on the spot. Now, I think Andrew brings up the key point, which is, by sanitizing the live stream, are you creating a derivative work? And that's going to be the key to the case, it seems to me. Again, very interesting, novel issues potentially under the Copyright Act that'll be fun to watch.
Right. If that's indeed what they're doing, that seems like the technology must be pretty impressive. If you can, I don't know what, out of the gate, they say they'll be supporting Netflix and Amazon and HBO through Amazon channels, and that Hulu, iTunes, and Vudu would follow if they could, have a filter that would work with all those services and others. That seems like a pretty big step. And secondly, I mean, all kidding aside, for there's not much left to Game of Thrones once you try and sanitize it. There's certainly a market for the way that television has been. Particularly HBO shows and other, what do we call them? Premium channel shows, Showtime and Stars and others have really, really been deciding lately that we've got to show you a lot of blood and violence and outrageously over-the-top stuff to keep you watching us. I feel like they've definitely gone in that direction. And not everyone wants to see that. And certainly they don't want their kids to see that until they're, properly seasoned.
There's unquestionably a market for sanitized content. I don't think there's any question about that. VidAngel, I think, quickly raised $10 million in funding to support the original business model that it launched. So I think there clearly is a business model associated or a demand for this business model. So it does raise an interesting question, kind of like what we were talking about with respect to the Star Trek mashup about the harm for the original work. Under fair use, one of the arguments, one of the elements that's very important is whether you're damaging the market value of the original work. Now, it could be that a lot of these people that are purchasing the sanitized versions wouldn't otherwise purchase the original work. So it may be that, look, there's not going to be harm in the sense that this is somehow siphoning off customers, because these customers may not stream the original anyway. So this is going to be, from a copyright perspective, really interesting to see play out.
Yeah, the way I would push back on that a little bit is that in my view, the key aspect of the places you'll boldly go, which is just delightful. I should have added that in that segment. Is that it was transformative of the character of the work, and I don't know that stripping out nudity or bad language or whatever is really going to be transformative of the underlying work, right? So I mean, that's just the way in which I would look at it is not, you may be creating a new market, but the question is, sort of to whom does that market properly belong? Should 100% of that value go to VidAngel when 99% of the end product is something that was created by somebody else, and what you've done is sort of taken away from it rather than, added anything new on your own?
I totally agree with that. We look at fair use as a kind of a sliding scale. So the more transformative your work is, the less important the other factors become. Right. But if it's not transformative, then you're going to have a pretty hard time prevailing as a matter of fact under fair use. So but I agree with you. I think the two different works at issue here, you could make a pretty strong argument that All the Places You'll Boldly Go is much more transformative than simply sanitizing a work that's streamed directly to a consumer.
Yeah, I agree.
Matt, anything to weigh in on here?
Yeah, I think that the another good analogy for this is to their new model. I think that their bad model, they just should have talked to an attorney first. I think their new model, it seems like they did get some input from someone who at least could make a plausible argument for how to make this work. I think the interesting analogy is for translations of where I think you guys talked about it before I came on the show, but where you'll see Japanese television and you can have it translated into English or something like that. And in technologically and more legally, this is a lot more similar to that if all of it's doing is blocking out parts of the show and perhaps providing different audio for parts of the show. So I think that, but strategically entering this market by just saying that we're just going to rip your videos and then sell them, it was just a bad play. And I think that I think the court will rule on their fair use defense on the basis of what they did earlier a little bit. I just think that's the way it works.
All right, we have one other copyright story to discuss here today, which we could have just done under entertainment and Hollywood, but we'll go ahead and roll our other copyright bumper for you just for fun. More fair use law being made over the musical Jersey Boys, the story of the Four Seasons, the 1960s pop group. Here, there was a dispute over whether use of an autobiography in the musical was fair use. We had a jury that found it was not recently in a federal court in Nevada, and the judge came in when the jury verdict was challenged and found, the judge thought that it was and set aside the verdict. So another big fair use determination here in favor of the application of the doctrine. We have a determination here that the play was doing one thing, and the autobiography was doing another, that the latter was more informative and the play was more of an entertainment vehicle, and that use of the biographical material did not here entitle the widow of one of the co-authors who sued to royalties or infringement damages. Mike, did you take a look at this?
I did. I thought it was very interesting, highly unusual for a trial. This was like a 2-week trial, 15 days of testimony that were heard by the jury. As I recall, there were like 8 or 9 different instances that the jury was asked to consider whether those instances of the play infringed on the autobiographical work. The jury came back, as you noted, Denise, and said there was infringement, there wasn't fair use, and ultimately said 10% of the success of the play was attributable to the autobiographical work. So when you're talking about a huge hit like Jersey Boys that has made millions, hundreds of millions of dollars, you're talking about a very significant, 10% of hundreds of millions of dollars is, not an insignificant amount of money. So ultimately, the court was asked to, the defendants moved for judgment notwithstanding the verdict, asked for a new trial, and ultimately the court held as a matter of law that this was protected by fair use. I think the court had mentioned that if you looked at the 9 different elements that were at issue, there were only 145 words that were copied from the autobiographical work that could be potentially infringing. And the court said, look, that's 0.2% of the overall dialogue. So you can't parlay 0.2% of the dialogue from the play and somehow extrapolate from that 10% of the success is based on the autobiographical work. So the court just said, look, it's just too speculative. There isn't sufficient evidence for that. And ultimately, overturned the jury verdict. Very significant determination here.
Yeah, definitely. And it could be headed to the Ninth Circuit, which has been deciding a lot of fair use cases recently. Andrew, any thoughts?
Yeah, I agree. I think sort of a couple things here. Number one, this is yet another decision that applies fair use in the context of an obviously commercial work here. Jersey Boys, the wildly successful musical. The interesting aspect of the sort of percentage comparison arises because most of the actual Frankie Valli songs had passed into the public domain, and there was previous analysis that the earlier what's referred to in the order as the capital W work, but that's the 90s autobiography, that there was no commercial market for that autobiography. And so in this case, it was the combination of those two things, minimal drawing from the non-commercially viable autobiography, and extensive use of the songs, which comprise most of the musical, that created the commercial value here. So it falls in the same line as the previous cases that we've talked about, where the key questions are how transformative was the work, and applying that fair use doctrine, extending it in a case where there's like this goes beyond fan art and the Star Trek cases where there's sort of some how much are you using of that Kickstarter to pump back into the project versus pay the actors versus this is clearly a for-profit work, and so I think that's in my view that's kind of the significance here. That and the loving descriptions of Jersey Boys in this 38-page order. So.
The judge was clearly a fan. Good.
Yeah, but most of my show's listeners are non-lawyers, so whenever I can give a good reason for lay people to read legal opinions, I try and seize on that. So this is a good one. This is worth reading if you're not a lawyer. So
yes, our favorite example is when briefs include Klingon phrases. Always makes for good reading. Go ahead, Mike.
I actually had a non-lawyer ask me about, well, why would there be a jury trial just for the judge to unwind the whole thing? It's a fair question. Oftentimes I think judges will send a close case to a jury or something that could be argued either way potentially, and they see what the jury's going to do with it. And then they decide to assess the situation after the jury's already ruled and they have the benefit of the jury's determination, and then they can look at the evidence anew. But it's not a wasteful exercise by any means to send it to the jury. I think in most instances, judges probably send it there to say, hey, let's see what the jury does, and maybe they'll get it right. Maybe they won't, and if they don't, we can always clean it up afterwards. So.
Right. And I wonder too, Matt, if this could have been an example of what you brought up a moment ago regarding VidAngel, of people not doing their legal homework on the front end. It worked out for the people putting on the show, Jersey Boys, this time, but I'm reminded of the fact that the huge smash hit Hamilton is based on Ron Chernow's biography of Alexander Hamilton. And, rather than leaving anything to chance there, they immediately, when deciding to make Hamilton, made Chernow a collaborator on the musical, and very concretely based the musical on his book, so there wouldn't be any misunderstanding. Now, here the co-author had actually passed away, and it was his wife who brought the suit. But what do you think about trying to address these issues on the front end?
Yeah, I think it's true that that you should take care of the front end. I also think that it's more likely the less you're relying on another work, the more likely you're going to think that it doesn't matter. It doesn't, they only used 142 words. If they would have based it solely on there, I can't imagine them not including him. But right. It's these these issues that are kind of off to the side are going to be the ones that end up in litigation.
Indeed. Also, something that can wind you up in litigation more often than not these days is your use or your client's use of social media. So let's look at a social web issue. One of your colleagues wrote this up on the TMCA blog, Mike, about P. Diddy posting a photo of himself to Instagram. Must have liked the photo, must have wanted to share it, but never got permission to use that photograph, and apparently wasn't just resharing it in some kind of licensed way, as you could do from Instagram or perhaps another photo sharing service. Can you tell us more about this?
Sure. This is another good example of how copyright is alive and well in social media. I think as a culture, we share so much, and as my colleague pointed out here, overshare so much as well, that sometimes copyright gets lost in the mix here, in the process of sharing and oversharing. Companies, even well-established companies and individuals, will overlook copyright concerns. This was a picture that was taken of P. Diddy at, I believe, a Manhattan school. It was taken by a photographer. The photographer had licensed out this particular photo to Rolling Stone or some other magazine, as I understand it. And then Bad Boy Records, I think, was responsible for posting this particular photograph. And maybe it was posted on P. Diddy's Twitter feed, and ultimately got significant exposure, lots of likes, lots of comments, and the owner of the photograph, the photographer, did not take kindly to it. So it's, posting something without permission on social media, Instagram, or elsewhere. Actually, sorry, I think I said Twitter. I meant Instagram is where the photo was published. But in any event, posting copyrighted content on social media or elsewhere can potentially get you into copyright hot water.
Right. And I think it's another good example of something that's come up a lot for us on recent shows, of how celebrities and people with large influential followings on things like Instagram don't have a lawyer sitting at their right or left hand whispering into their ear about whether what they're about to post is okay or not. And I could see how someone without that background and resource might think it's a picture of me. I'm going to post it. I'm the subject of the photo. But no, that's not how copyright in photographs works. You have to worry about who the photographer is. Andrew, any thoughts?
No, of course we've.
Oh, sorry, Mike. Go ahead.
Yeah, I was just going to mention, of course, something we've talked about at length today already is the concept of fair use. And one of the important fair use determinations is whether the particular use is for newsworthy or commentary or criticism. It seems as though there's a pretty decent argument that, hey, look, this is posted for purposes of showing where I was, and this is a very important social event. That I was there at some ribbon cutting ceremony for some school that was just open. So, they're not totally at sea here. I mean, there's certainly arguments that what they did was subject to fair use. But conceptually, using somebody's photograph, posting it to social media or elsewhere without permission is kind of a prima facie violation of copyright unless you can show that there's a fair use or other legal defense associated with that use.
Right. And what I was alluding to earlier is that people might, hear us say this and go, oh, well, then if I am resharing or retweeting or otherwise posting on my own face a photo that I've seen show or on my own page, if I posted it on my face, then you wouldn't be able to have this conversation. A photo that I've seen elsewhere, the way the social media services handle that is if you delve into their terms of service, any service that allows resharing, reposting requires, in general, the original person who's posted it, assuming that they have the proper permissions, to grant a license to the other users of the service to repost it and share it around. And that's how social media works, how things go viral, is there's actually licensing built into the process. But that's not how this photo appeared on Instagram. They did not reshare it from the photographer's site. And that's something too to bear in mind. Every time you see something that's posted on social media, scratch your head and wonder a bit whether the person who has the rights to it actually put it there or authorized it being there. That's something that you might not be able to answer yourself. Andrew, any further thoughts?
Yeah, well, this is the first case that I have ever seen involving copyright on social media where it is the celebrity sharing a photo of himself. I mean, to me, that's kind of the interesting aspect is, how this overlaps with, your right to control your likeness. And, presumably at some point, you would want to go back and unwind the original licensing agreement to the photographer and see, does that agreement have a clause that, it later enables you to, assert rights over the worker. Obviously I don't know, what that agreement looks like. From a practice perspective, I'm sure you all know, but on Google Images, you can filter by license if you go into the advanced settings. And so, when we do little clips for our show or, stationary show graphics, you can just do a, free to use modifier share even commercially. And that's, again, don't take legal advice from a podcast or anything, but that seems to be sort of best practice in the industry.
So, Matt, do you think there's any chance that as P. Diddy and others continue to get copyright law wrong, that copyright law would evolve to let Diddy be Diddy, to take into account that people may have a policy reason to be able to post photos of themselves?
I think Andrew provided kind of a good point for that, in that, does your right to manage your own, the image of yourself, could that supersede the copyright law? And I could see a court saying that in certain instances. I mean, we give pretty broad rights to your personhood and your personality, and I could see that. I do want to quickly throw in that I'm surprised that P. Diddy is still P. Diddy. I think this is like the first decade where that's ever happened. Yeah, so I think that that's a legitimate claim, and it would be really interesting to see how the court deals with those two competing rights.
Yeah, I think so too, and I think the point you two are raising gets you then into privacy law and, what can be photographed of you in public and how public photos can be used, whether it makes a difference whether you've just been candidly caught out in the open or whether you've sat for a photo shoot. I think the determination might be different depending on the situation.
And it would be different depending on the state.
Mm-hmm.
Your right to publicity is, larger in California than it is in, Michigan. So
right.
That's because you've had more cases about that because you have celebrities other than Tim Allen, who we still kind of hold. But so I mean,
you're holding him hostage.
Yeah, he does all our commercials. He does a great job of doing the Pure Michigan commercials. So it is like, that would conflict within states, within jurisdictions. And so that would be a really difficult but interesting question for the court to take up.
Yeah, it would. All right, we have one other area to get to before we go ahead and wrap up the show for you today. We're going to look at a story involving journalism and agreements that apply to people working at journalistically oriented web companies. So this caught my eye. I hadn't actually, I think, read the work of social news outlet Now This, or maybe I haven't. It just hasn't registered. But what they are being called out for is the fact that they are making their new hires sign contracts that forbid them from taking jobs at competitors, including CNN, Vice, BuzzFeed, and Vox. They're here in California, we call those non-compete agreements. And here in California, we do not hold truck with them. They are largely unenforceable with very narrow exceptions in the state of California. Things may be different in New York, but the New York Attorney General may decide to weigh in on this one now, because the company in question has confirmed that some of its employees have non-competes in their contracts that are pretty onerous. Andrew, have you taken a look at this?
Yeah, I have. So you're absolutely right. I mean, California has a statute. It's been on the books for 50 years that broadly bans the enforcement of non-competes. Interestingly, that was sort of judicially read out for about 40 years, right? It's only relatively recently that the Supreme Court sort of read back in the kind of literal application of the statute. And as a consequence, we've moved to a regime in which now economists are sort of asking the question, does the environment in California in which non-competes are sort of broadly held to be non-enforceable, is that part of the pro-business landscape that's enabled California to be, number one in the tech industry? And there have been a lot of, obviously. It's not hard to find liberal authors arguing against the enforcement of non-competes. But for a long time, that's sort of how it broke down politically, right? Like if you had a lefty state with a lefty court that wanted to side in favor of the individual who was being subjected to this sort of onerous non-compete clause, they would the lefty courts would side with the individual. The more conservative pro-business courts would side with enforcement of contract. But there's real literature now that suggests no, strictly enforcing non-competes is anti-competitive, makes it hard for well-funded startups to go solicit, middle managers at Google and Apple and the like, and entice them away with, dreams of equity and participation, that sort of thing. So as a result, lots of states are kind of moving in the direction where they're sort of curtailing back the enforcement of non-competes for pro-competitive reasons, not just sort of pro, sympathy with the individual. This case, this is 2 years for anybody working in a media outlet going to a competitor. And the operative test in most other states is called the legitimate business interest test. It's a standard balancing test. And it's hard to imagine that a court would enforce a 2-year nationwide non-compete against somebody who just happens to be working in a media outlet. Like that strikes me as unlikely.
Right. And this is, if you haven't heard of Now This, and maybe you have, it's actually ringing familiar to me. You've probably heard of the Dodo and Thrillist and maybe Discovery Communications Seeker. They are all part of Group 9 Media, and that's the company that has this agreement in place with their employee contracts. One thing I've noticed in California over the years is even though it's very clear that with very limited exceptions, non-competes aren't enforceable in California, that doesn't stop them from cropping up in people's contracts all the time, because companies, maybe they're based out of state or their counsel is out of state and they just, they're using whatever contract they've used for all of their employees in some other state, and the non-competes show up in there. And so employees then have to question whether they want to be, the squeaky wheel that says, hey, you realize that's not enforceable in California, or they just shut up about it and know that they're, not going to be bound by it further on down the line. Matt, any thoughts on this?
Oh.
Sorry.
I'm interested in Andrew, we can jump back to you. I'm interested to know whether a non-compete is enforceable out of state.
Yeah.
Well, yeah.
And, go ahead. Go ahead, Denise.
Just one thing that jumps to mind when considering this is even if these employees and these companies are headquartered in other states, whether the fact that they do business in California has any role here. What do you think, Andrew?
Yeah, and so the answer to that, there was actually I can't recall the name of the lawsuit off the top of my head, but it was a dispute over a contract between an employer in New York and employees in California, and so as you might imagine, both parties raced to the courthouse. The parties that got to the New York courthouse, the employer, got there second, but nevertheless persuaded the judge to issue an injunction enjoining the California courts from proceeding. And the basis was, because this is a done deal in California, and New York has a legitimate public policy interest in enforcing non-competes, and this was going to be a dead letter in California, so it shouldn't just be decided by kind of race to the courthouse. I will look that up if you want it for the show notes, but it's a clear example of kind of how that sort of forum shopping can come into play. And the court, the New York court didn't prejudge the non-compete, right? It just said, we want to consider it, and if we allow the California court to proceed, they're going to hold it invalid. So,
got it. Interesting stuff. Mike, any thoughts?
Yeah, I mean, a nationwide ban, I mean, I guess you'd be forcing people to relocate to a new country so that they could stay in the media biz, which just seems inherently unreasonable for all sorts of reasons. But I can speak here in Washington to what our law is. Non-competes are enforceable, but they've got to be very tailored to a particular geographic region. There's been some cases that have said outside of a 15-mile radius is just too onerous. So, making it nationwide is just it seems like a non-starter.
Yeah.
All right. Well,
there was a big box company. I was just going to say that there was a big box company that tried to do the same thing with its shelvers and cashiers, and had a 2-year non-compete. And it's just, you have to look at what interest is that protecting of the employer, right? Like what trade secrets, is your cashier or your, mid-level journalist really taking with you to the competition? And it's hard for me to see that any court, even ones in state that enforce this are going to say, yes, there are significant interests worth protecting here that justify taking away a person's right to seek employment for 2 years. So.
Definitely. All right. Well, we'll continue to watch that issue and let you know if there are any more developments. And yes, let us know the case that you were thinking of, Andrew, and we'll stick it into the show notes. With that, I think we're just about ready to get into our concluding material of the show. What you've all been waiting for, I'm sure what people tune in for week in and week out. We always end with an animal selfie of the week. I love this one because it raises a whole host of legal considerations. 19-year-old Tyreek Ty Ben-Uriz, if I'm saying his name correctly, was in California chilling on the beach and had his phone, was posting to Twitter. Sea lion came along and presented itself and got in Ty's photo. Can we show Ty's picture with a seal boy, he says, a little bit further down, in front of the lifeguard tower right there. So if you can show the text as well, there you go. You can see he's using the horns as his emoji after I just took a pic with a seal boy. So more prior art on that. But then the fun reaction he got on Twitter was people admiring the seal's demeanor and posture and expression. That seal took a picture. You just in the background. That seal is posing. This is her debut. You might have got a picture with seal royalty, a seal pop star, the Rihanna of seal culture. So people had a good time with the seal's attitude. Legally speaking, though, I did not go before the show and look up the Marine Mammal Protection Act, but I do know that you are supposed to keep some distance between yourself and marine mammals in California and I believe elsewhere. So Ty might want to pay heed to that, in addition to the fact that seals and sea lions can be big, powerful, dangerous animals. We saw the girl get hauled off the pier recently. And also, one thing that you might not think about, now this looks like a fairly well-grown seal, or sea lion, at least a juvenile or an adult. But on the East Coast, apparently, there is a real rash of people attempting to take photos of themselves, selfies of themselves with seal pups, which is a really, really bad idea. Or here in California, sea lion pups would be the equivalent, because mamas of those pups do not like you getting close to them, and they can definitely make your life scary or dangerous if you do become a come-between a mama seal or sea lion and their pups. My across-the-street neighbor was just telling a harrowing story the other night of how on his first abalone diving expedition, among the various god-awful things he went through getting into the cold Pacific and hunting for abalones off California, he actually got grabbed by a sea lion and taken to the bottom by his fin. And of course, when you're, maybe not, of course, you might not know that when you're hunting for abalones off California, you cannot use scuba gear. You are free diving. You're using just a mask and snorkel. And he got hauled to the bottom because, as he learned when he finally got himself up and out of the situation, there was a sea lion pup right there where he was diving. So meanwhile, even if you might find the Rihanna of sea liondom, please do be aware of the laws that protect marine mammals and also protect your own safety. So there's our animal selfie of the week. Our tip of the week is a tip that comes actually from Andrew's Twitter feed and is nicely in keeping with our VidAngel discussions of Game of Thrones. If you're someone who would be inclined to have a cleaner, more palatable, more public place version of Game of Thrones, you might want to check out a Game of Thrones pop-up bar in Washington, D.C., serving such cocktails as the Lannisters send their regards. Have you gone here, Andrew, or are you planning to?
I have not gone there. The bartender behind it is a friend of mine, Derek Brown. he's a genius, and he has these 3 bars that interconnect, and has totally made them over into this Game of Thrones themed little mini city. And as a lawyer, and therefore as somebody who likes to drink recreationally, I absolutely will be down there to paying it a visit. And Matt, I'm happy to buy you a drink if you're in town. So.
I'm happy to buy you one right after that. So that sounds good.
Excellent.
Excellent indeed. And then finally, our resource of the week is an opportunity actually for you or those you know who you share this with to be a resource for someone else. And that someone is Mike Masnick and Tech Dirt, longtime blog. I forget exactly how long Tech Dirt has been around, but it's been around a long, long time, since the mid-2000s at least, maybe going further back than that. We have discussed on the show how Tech Dirt and Mike Masnick are engaged in litigation involving posts that deal with who is the inventor of email. Mike and Tech Dirt have written in depth about an individual who claims to have invented email and has various websites that proclaim him the inventor of email. Mike has taken issue with that and done journalism around that claim, and it has landed him in a pretty contentious lawsuit. We have some video we can show you to give you an idea what's going on there.
Company. This is the point where I'm not so modest. I think we've been able to punch above our weight. Our coverage and our research have been at the heart of many of these issues, as Mika said, in many of these key debates around copyright and net neutrality, surveillance and encryption. We've been deeply involved in them. And because of that, we've been able to win awards. We're regularly quoted in the press. And this one I'm particularly proud of. During the SOPA PIPA fight, we were the most linked to source for news about that fight, beating out the New York Times, the Washington Post, and many others. And that was from a study by Yochai Benkler at Berkman. And I'm proud of what we've accomplished. And I'm, oh, jeez. I only have 12 minutes, don't do that. I'm particularly proud of what we've done on free speech. And in particular, free speech being a topic we've written about many, many times, and in particular something associated with free speech, which is called anti-SLAPP laws and legislations. Now, some of you in the audience probably know what SLAPP, this sort of weird acronym, stands for, but I'm assuming some of you don't.
So
really
Mike goes on here and talks more about strategic lawsuits against public participation. They are attempting to assert anti-SLAPP claims in the litigation against Tech Dirt. They have very good lawyers, but can use all the help that they can get on the financial front. So if you head over to isupportjournalism.com, that's where you can support Tech Dirt. Let them know that you think they've been doing a good job all these years and would like to see them get through this suit. Mike, anything to add?
Well, hold on a second here. I thought Al Gore invented email. Am I wrong on that?
He may be the next one that Tech Dirt decides to take down on that claim. At least he's not going around proclaiming it right and left anymore. Andrew, any thoughts on that one?
No.
I know. Matt, you're the one who raised Mike and Tech Dirt as we were prepping for the show this week. So anything you want to add?
Just that I would love to criticize this gentleman, but I can't afford the lawsuit, and something seems wrong about that.
Yeah, absolutely. So, and indeed, you know, Mike is not the only one who has delved into this issue and been unsuccessful at it. Gawker was the first go-round, or one of Gawker's publications. So I'm not saying that Mike's going to be unsuccessful. They are fighting it. And of course, Tech Dirt is alive and well and publishing wonderful resources very related to everything we discuss here on the show. So if you'd like to show your support for Tech Dirt, that is isupportjournalism.com, and a chance for you to be Mike's resource of the week. How about that? We are so glad that you've been able to join us this week. We do the show every Friday at 11 o'clock Pacific time, 1800 UTC. You can join us live, play along while we record. But if you can't do that, don't worry about it. All the shows go up at twit.tv/TWiL. After we record, they are there in perpetuity for your consumption and pleasure at your leisure on whatever device you please. So please head over to twit.tv/TWiL, dive into our archives, decide how you want to watch or listen to the show, or join us live if you can. It's always fun to have a great group in IRC, as we have had today as we do the show. And it's also amazingly fun and wonderful. And we're so blessed to have guests come along each week and join us, like Andrew Torres. Andrew, it's been so fun getting to know you here on the show today.
Oh, this was great. I had a terrific time, notwithstanding my mental inability to come up with Black Sabbath on the spot. I really, really appreciate the invite. This has been a lot of fun, and I'm looking forward, Denise, to having you come on my show.
I'm really looking forward to that, too. That'll be next Thursday. Do you also record live? Or so while we're recording, will we have an audience, or will it be something that's after the fact?
No, due to my inability to correctly recall 70s metal bands off the top of my head, we record, but we record 2 episodes on Thursday and then release on Friday and Tuesday. So, we have a kind of a minimal delay, and
that's great. Well, I'm really looking forward to being part of it. Thanks so much for being here today, and I will look forward to seeing you next week. Also, look forward next week to seeing my wonderful co-host, Matt Curtis. Hope you have a great week in the meantime, Matt.
Well, thank you so much for having me on, and I look forward to heading off to the Game of Thrones bar.
Oh, yeah, that's
absolutely.
Gonna be great.
That's in your neck of the woods right now. So you'll have to report in. Please do. Let us know what cocktails you found there and whether it was any more cleaned up than the actual show is.
I'm going to stay away from the incest cocktails, and that's all. That's my only rule.
Yes. What else? Oh, IRC exists to be able to help us out when we forget things like Black Sabbath. So thank you so much, IRC, for being with us here today, for playing along and enjoying the show. And thank you so much, Mike Keys, for doing the same.
Thank you. What a great show. Andrew, great to have you with us. And thanks for coming. Very enjoyable. And rock on, everybody.
Exactly. Woo, rock on. We will be back next Friday on This Week in Law. If you'd like to get in touch with us before then, please do. We're all on Twitter. Our guest, Andrew, today is OpenArgs on Twitter. Or you have a personal Twitter, too, that you can point people to?
Yeah, my personal account is PA Torres Law, PATORREZLAW. My show is Opening Arguments, so that is OpenArgs, like you said, OPENARGS.
Great. So you can get in touch with any of us on Twitter. You can get in touch with me and Mike and Andrew about the show at our twit.tv emails. I'm Denise at twit.tv. Matt is Matt C at twit.tv, and Mike is Mike at twit.tv. So let us know what's on your minds, who we should have on as a guest, any reactions you had to what we've discussed or further thoughts. We love hearing from you. Please do keep it coming. You can also find us on Facebook. And as I said, all of us are on Twitter if you want to get in touch with us those ways. Those work too. And until next week, have a great one. We'll see you then on This Week in Law. How do we do it? With the finger over the fingers. There we go.